Hi friends, I am your friend Namish Nigotia Advocate and you are watching my YouTube channel Legal Advice for Everyone. Friends, in this video, I would like to discuss protest petition. What is protest petition? When it can be filed? Where it can be filed? What magistrate used to do after filing the protest petition? How to draft the protest petition? And what are the relevant citations of Honorable Supreme Court with respect to the protest petition? Before I proceed further with my video, I would like to request that if you have not subscribed my channel, please subscribe my channel, and if you like my videos, do like and share my videos. Friends, protest petition, this term has not been defined anywhere in criminal law, neither in cr.p.c, nor in IPC, nor in any other criminal law. It is a purely judicial innovation. What is protest petition? We would like to study and we would like to know. If a victim or complainant filed or lodged first information report before the police officer, the investigation officer used to investigate the matter. After collecting the material evidence, he may file the charge sheet or he may file the final report in negative form. If he chooses to file FR, final report in negative form, before the magistrate before accepting the FR used to issue notices to the victim or complainant, and in that notice the victim or complainant has been asked, do you have any protest against the closure report or final report? If the complainant chooses to protest that final report filed by the investigation officer by filing a petition, this petition is known as the protest petition. I think now the concept of the protest petition may be clear to all of you, sir. Then the question arises that where it can be filed. So it can be filed before the magistrate having the jurisdiction or before the same magistrate where the investigation officer has filed final report in negative. Then again question arises when it can be filed. The protest petition can be filed as soon as the complainant receive a notice from the court that the police officer, investigation officer has filed the final report in negative. Do you have any protest? In that case, on the very next date of hearing, which has been mentioned in the notice, the complainant or victim has to present before the court, and he may file the protest petition protesting the final report filed by the investigation officer. Now, what a magistrate can do after receiving the protest petition? This is very important and relevant, and I would like to discuss one landmark judgment of the Honorable Supreme Court. The citation is Vishnu Kumar Tiwari versus the state of Uttar Pradesh, and it has been decided on 9th of July 2019. And the Supreme Court has given the following verdicts, conclusions, that what a magistrate can do after receiving the protest petition. He may agree with the conclusion of the police and accept the final report and drop the proceedings. Number 2. He may take cognizance under section 191B cr.p.c and issue process straightaway to the accused without being bound by the conclusion of the investigation officer. And the third, he may order for further investigation, and if he is satisfied that the investigation was made in a perfunctory manner, then he may proceed further. Then the fourth is, he may, without issuing process and dropping the proceeding under section 191A cr.p.c upon the original complaint or protest petition, treating the same as complaint, and proceed to act under section 200 and 202 cr.p.c, and thereafter record the statements of the witnesses produced by the complainant and proceed further as if the magistrate is treating it as a complaint. So he may do all the four things. That's a very relevant and important observations of the Supreme Court, that after receiving the protest petition, what a magistrate can do. I would also like to discuss one very important media highlighted case, Arushi murder case. What happened in this case is that the CBI has filed the closure report or final report in negative. The father, Dr. Talwar, has filed the protest petition. The magistrate court, instead of CBI court, instead of issuing notices, issued summon to Dr. Talwar, father of the Arushi Talwar, and his wife Dr. Nupur Talwar for committing the murder of Arushi Talwar and tampering with the evidences, and proceed further. Now the question arises, how to draft a protest petition. So while starting drafting of the protest petition, please listen carefully. That's very important aspect, how to draft the protest petition. First, you have to mention the name of the court. Then you have to mention the FIR number. Then complainant has to mention his name, father's name and address, versus the name of the accused, father's name, address. Then section in which the FIR has been launched, that those all sections has to be mentioned in the protest petition. Then name of the witnesses who ought to be examined but has not been deliberately examined by the investigation officer. That is very important aspect. What happened? That IU used to pick and choose the witnesses if he is not doing the fair investigation. Many times it happens. Then material witnesses has not been examined and IU used to file the closure report or final report in negative. So the person who is protesting that final report has to specifically mention the name of those witnesses which ought to have been examined under section 161 cr.p.c but has not been deliberately examined by the investigation officer. Then the next step is, if there is connivance of investigation officer, please mention the name specifically of the investigation officer and further mention that there is a connivance of the accused and investigation officer, and that is why, just because of that connivance, just because of that influence, the investigation officer has filed the final report in negative. Then if the investigation officer has not annexed medical report or could not send the victim for the medical examination, please mention that fact in the protest petition. Then the investigation officer has not investigate in the particular section which has, in the light of the particular section which has been mentioned in the first information report, please do categorically mention that there is no conclusion or there is no investigation happened with respect to this section under which the first information report has been launched. So that has to be very specific. If the investigation officer has not recorded statements of some witnesses, please do mention that these witnesses ought to have been examined. And the relief, that kindly accept the protest petition, kindly take the cognizance, kindly proceed further or direct the investigation officer for the re-investigation or further investigation, and kindly record the statement in accordance with law and kindly punish the accused. So these should be the relief, and this is how the protest petition should be drafted. And the complainant should also annex all the relevant document, all the medical documents, all the witnesses before the magistrate, so that the magistrate may treat those witnesses, those evidences, and take cognizance as against the accused. So I would like to sum up this video. Thank you so much, friends.